Okay, so I'm Adam Richlin. I run Lightbulb Grip and Electric. I think I've gotten a chance to meet most of you. We're recording this for people to see at home. So Lightbulb Grip and Electric, we're a rental house in Brooklyn, New York. So I do a lot of lectures. We call them late nights at Lightbulb, where we talk about topics like this. And I feel like this is one we covered about a year ago, talking about the new Freelancing and Free Act, but we never had a chance to come back to this. So we're now hitting, we've passed, was it a year and 5 months or so since it came out, and I'm still finding people who don't know about how this covers and helps New York filmmakers both get paid and make sure they get covered while they're doing their work. Okay, so Sam, let's move on for a second. Okay, so why are we discussing this? All right, so let's jump into a couple of statistics, because I had a lot of fun digging this up as we were getting the talk together, and they've compiled a lot of data about as New York City has started seeing these freelancer cases coming through. So 91% of freelancers in New York City have had an issue with project payment within their first 3 years of being in business. Okay, so out of this group, put your hand up if you have ever had trouble getting paid. This means not getting paid by net 30. This means somebody saying, "Oh, your rate was lower than I told you before. Sorry." Yeah, I mean, keep your hands up. Come on, I'd like them up for a second. Okay, now everybody take a look around for a second. That's more than half the room. Okay, so when I say 91%, I'm not kidding. This is a real big issue. All right, so yeah, and 28% of freelancers have done work without a contract. How many of you guys are sticklers about having a contract before you step onto set? I know I'm not as good as I probably should be. There's like one hand up in the back, or two hands, that's it. Okay, so a lot of us are not making sure we're covered, making sure we've had conversations with producers, making sure we've clarified exactly what is expected of us, how much we're getting paid, when we're getting paid it. All of these things we take for assumptions quite often. That leads to problems. Okay, so let's jump on. So 46% of complaints come from freelancers between 18 and 29. And so most often the youngest group in our community is the ones who are the most taken advantage of. Now, the Freelancing and Free Act, in their first year of let's call it business, has reclaimed over $250,000 for filmmakers. And this is New York State knocking on doors on behalf of freelancers and forcing clients and hiring parties to come to the table and face up to what they made promises for. And so a lot of this is simply just telling people, not even billing in excess or creating late fees and fines. It's simply just telling people you have to pay what you originally agreed for. The law establishes and enhances protections for freelance workers, specifically the right to a written contract, the right to full and timely payment, the protection from retaliation, which is a thing I didn't even know. I just learned in the last few days about this as well. Support from New York State in collections efforts, and access to legal services if you pursue a case. So if you're chasing a customer and you've hit net 30, they haven't paid, you hit net 45, and you start getting really frustrated, you really only at the moment have three options. You're either taking them right to court, which ends up taking a lot of time and will cost you a bunch. You send them a threatening letter from a lawyer. That's one. Costs you to hire a lawyer. Or you go into New York City's Office of Labor Protection and Safety, the people that will help you interface with the other party and make sure now you have the weight of New York City coming down behind them as well. All right, so we have to set a couple bounds for what's covered in the law. So it only covers jobs that are $800 or more within 120 days. So if you are paid at any point $800 within a 120-day span, or you're supposed to be paid that, then this counts. It happened partly or fully in New York State. And so if you make an agreement and you start a job, let's say part of it happens in New York City, and then you go out and do 2 days in Connecticut and a day in Philadelphia, that still counts as working in New York. Because there was a distinct period of time where you did a job and you completed work in New York, and then you didn't get paid for it. It started after May 15th, 2017. By now, pretty much, I guess this is, we're far enough away from the law, it's been a year. And then the work is done by a single freelancer or a sole proprietor LLC. So if you start your own little production company, or you start your own shell company to support you as an individual freelancer, this will count. If you are part of a larger company, then this law may not count. So it's meant for single freelancers who don't normally have a lawyer on retainer, or don't have access to legal services, to be able to use the New York City for support. All right, so if you fill these 4, then you're covered by the Freelancers and Free Act, which I shortened to FIFA here, and the Office of Labor Policy and Standards. That's the word I was looking for before. The Office of Labor Policy and Standards. These are the ones who actually will come down and support you, and actually sit across the table and give advice on how to implement this. Okay, how are we doing so far? Is everybody with me? Yeah? Okay, wonderful. All right. So let's break a couple of those pieces down now. So written contract, you have a right to a contract for your work, and you are actually now required to have a contract for your work. The client or hiring party is the one responsible for providing you a contract. Now, for too long, the clients have been able to say, oh, hey, sorry, we already passed the phase where you're supposed to have given us a contract, so we'll just do this one under the table, right? No. Now it's their responsibility. If they're promising you pay and trade for work, they also have to provide you a copy of a contract. And when they do that, you have the ability to negotiate that contract. And that's when everything is laid out on paper, you decide what you agree with and what you don't agree with. But at some point, somebody has to start with a basic contract. And on the OLPS website, if you look up on New York City, they have demo examples of contracts that fulfill the law, and then sections of text that would be considered illegal content. And so you can kind of use that as a basis to start with, and then you might want to talk to a labor lawyer as well if you're getting into a bigger, longer-term contract that you feel may get gnarly. The work you're going to perform, the pay for the work, the date you get paid, and that you and the hiring party must both keep copies of your contract. Now, if you get into a situation where you kept a copy of the contract and they didn't keep a copy, then when you come in, your copy is the one that stands. At the same time, if you lose your copy, their copy, whatever they put down on the table, that's the one that stands. So something to think about, make sure as you sign in contracts, you're filing them away. I recommend taking pictures of things on a phone, because we rarely lose our phones, and that will give you a second copy and you always have access to it. So if it ever comes down to it, you print the pictures out again, great, this is the copy of the contract I signed. And so that'll help you, especially if you're working with really squirrely or gnarly customers who are planning on trying to get out of it however they can. Okay, so payment, you have the right to be paid within 30 days of your invoice for any completed work. If you do not have a contract, or do not have a deadline in the contract, the default is net 30. So I'll point out, you have a right to be paid within 30 days of your invoice, given that the terms of the contract say 30 days. So a very important thing to have in your contract is that it's either due on completion, which means net 0, or it's net 30. If you don't assign one, then it'll be then the default is net 30. If for some reason a customer comes to you and says, here's your contract, it says net 60, that's legal. It is, because you're making an agreement with another party, and it's up to you to negotiate that 60 down to something reasonable that you want it to be. So them just providing you a contract that says more than net 30 does not necessarily make it an illegal contract. Everybody with me? Yeah? All right, cool. Lots of nodding heads. All right. So if you're not paid properly, then the Office of Labor Protection and Standards has the ability to collect fines on your behalf, but this option is not necessarily exercised in every case. This is the thing when you go in and you sit down with them, they'll walk you through what they're able to do and how they're able to support you. I will point out at this point, if they choose to get a labor lawyer involved and you're in a situation that's an otherwise legal labor situation, let's say they're not fulfilling minimum wage, they're other things like that, unsafe work environments, the labor lawyer that you work with or that they assign to the case may choose to chase other avenues, other legal avenues around it as well. So that's another thing. Sometimes simply getting paid for one thing, if they threaten, oh, well, you have these 8 other things looming, that helps you get paid on just that one little, just pay me my wage part. Okay. So, all right, so the right to file a complaint. So you have a right to file a complaint with the Office of Labor Policy and Standards. They'll review the case. They advise you the next steps available. If they approach the hiring party, which frequently happens, they will be the intermediary for you. The hiring party has 20 days to respond. And this is a mandatory requirement. There are dedicated fines and problems that are created if they simply don't respond as well. And there are also ways to have default judgments. All right, so the OLPS will provide information to help you find a lawyer and understand the legal process as well. So let's move on one more. Okay, we're missing a slide in there. Oops. Let's go back one. Go back one more. Okay, somehow a slide vanished in there. Okay, there is another section in there that I'm missing a slide for that says that you have a right to file without threat of retribution. And so a very big thing, you can tell an employer straight up, I'm filing through this method. It's up to you if you want to look into how the rest of this works, so you're prepared. But if you choose to file in that method and they come back to you and tell you either they're threatening further legal action, if they tell you that they are going to blacklist you or tell anybody else that they can't work with you because of this filing, or they threaten to further withhold any other payments that you may be due in the future, any of those things are a legal retribution. Now, if you get this as an email or as a voicemail or something, and you go back into that office and you put it down on the table and say, hey, they just sent me this. At that point, it becomes a problem with the labor board. And that gets a lot bigger than us. That's the point where they take it off the table and they say, thank you, we'll take this from here. And at that point, the state gets involved. And so so that's a big thing to know. If you ever see anything like that from somebody who says that they're not going to pay you, it's one thing to dispute the dollar value that's on the table right now, but it's another thing to threaten somewhere else in your career or your livelihood. Everyone with me? Yep. Yeah. Okay. Wonderful. Thank you guys. Sometimes it's hard to tell when everybody's just staring, and when we're with me. Okay. So this is a pretty short talk, so I'm going to point you guys for a little bit more. There's an amazing resource called the Freelancers Union. If any of you guys are not part of it yet, you should be. So the Freelancers Union gets together and they offer healthcare options. They offer a lot of legal support and resources. Now, Freelancers Union covers a wide range of people, from graphic designers to web people to filmmakers, photographers, journalists, anybody who works independently. Yeah, if you want to take a photo of this, I see a couple of you guys taking photos. And then there's the Office of Labor Policy and Standards. And so this is the website from which all of the rest of the information will unfurl. And so if you ever have a problem with this, you look up Freelance Isn't Free and they come up right away. So in there's a whole listing on where the office is and how you go and file and stuff, and you just follow those directions. One more second. And God forbid you need it, the New York State Department of Labor. So they're on there as well. If you're ever stuck in an unsafe working environment, I also should have put up OSHA as well, the Occupational Health and Safety Administration. And this, I mean, like if you're in a work environment of a building that's full of asbestos, or you're stuck, I don't know, they want you leaning off the side of a building or something, and you get into situations that are truly unsafe, those are the guys that you're going to call to get advice on that, or if you need to file a serious complaint that they're continuously doing stuff that's illegal. Okay, so that is my quick talk on the Freelance Isn't Free Act. Feel free, if you want to check out in here, there's also some really interesting statistics about how they've used the act and how freelancers have filed in the different ways people have gotten involved with it. Overall, I think $250,000 is an amazing amount of money for us all to bring back in, and that was over about 200 cases. That's a very small number to make that much money back. So I think that's pretty cool. So yeah, you guys got any questions for me?
I have a question.
Okay.
The origination to be covered under this act in New York. Yeah. If you're a Jersey-based filmmaker and you're being hired, like, where does it start? Like, if a New York company hires you, or do you work in New York, it's considered under that protection?
Okay, so you end up in an interesting situation here. I'm not a lawyer. I'm not a lawyer. We're going to start this all with I'm not a lawyer and this is not legal advice. Okay, from the best of my understanding is if the work happens with feet on the ground in New York, whether that's New York City or New York State, that it counts. And if you're two New York companies that are both involved in this, and the project starts in New York and or involves New York at some point, then it will be included. If you literally both meet in Philadelphia for the first time, do the job, and then come home, I don't know that that covers it, even if you're both companies from New York. That's one of those things. You call them, or you file a complaint and see. It's free to file. It costs you nothing to ask them the question, and then they'll come back and say if it's covered or not. So there's no downside to filling out the paperwork and see. It's like a one-page, half-page application. Mark, what's up?
Is there any statute of limitations on filing?
So there is no statute of limitations on filing. As long as the job happened starting May 17th, 2017 and beyond, then it counts.
It doesn't cover retroactive.
It doesn't cover retroactive before May 15th, 2017, but it does cover everything from here on out. And so the thing is, the problem with setting an expiration date is that a company knows I just need to make it to 200 days and then I never have to pay this thing again. I just have to stall them for a while. So they don't put an expiration date on it intentionally. So if there is a point where you haven't gotten paid, at some point you get fed up enough and you're like, man, I'm just going to call the phone number. And then they take it from there. Or you work with them from there. Mr. Gabe.
Is there like a set of qualifications for the hiring party? And I'm asking because like I've been in a situation before where like I'm working on a project and I'm hiring a friend of mine, paying him $300 a day per week, and I'm over 800. So at what point do I need to worry about being a hiring party that needs to...
Okay. So what are the requirements for being a hiring party? Okay, so if you're hiring other people out, you need to know that you need to give them a paper contract, even if it's just a couple notes typed out on a sheet of paper that says the dates they're working, the amount that you're paying them, what defines their completion, what do you consider a finished project, and your terms for paying them, whether that's on delivery, net 30, net 60, whatever it is, and those are the basic defining requirements, but there is a specific list actually attached to this. There's a break off inside this on the first page of this website that says if you're a freelancer, click here. If you're hiring, click here. And so they'll walk you through the specifics. But off the top of my head, I believe that's the requirement. It doesn't have to be drawn up by a lawyer. It doesn't have to be something that's like 12 pages long. It just has to be a couple sentences and both of you sign it and you've got an agreement. And that's it. It can be written in plain text. Do we have any other questions? No? We're doing good. Okay, wonderful.